Very good morning to one and all. Today we are at the last live session on right to information and good governance, and we have with us a very special guest, Professor V.S. Mallar, who's been a professor of law at the National Law School. And Sir would be deliberating on the constitutional aspects of the right to information. Although we had organized this special session on the Constitution Day, that is the 26th of November, but owing to the cyclone, we had to delay it a little further, but better late than never. Before we request Sir to commence his session, we'll just give a small introduction. Although Sir needs none, but still for those for the uninitiated. Professor V.S. Mallar has a MA in economics and a BL from the University of Madras, and he also holds a LLM degree from Bombay University. He also has a postgraduate diploma in law and administrative law from the University of Madras. He was a lecturer in law at JSS Law College, Hubli during 1971 and 73, and he has also served as a faculty member of law at VM Salgaonkar College of Law, Panaji, Goa between 1973 and 1980. Sir was the vice principal in 1981. He has also been the dean, faculty of law, and chairman of board of studies in law of Goa University during 1986-88. He was selected and appointed as an assistant professor of law senior at NLSIU in May 1988 and as an associated professor of law in April 1992. He was elevated as an additional professor in April 1997 and as professor of law from December 1997. He has also been a visiting faculty at the Warwick University, UK during 1995. He has also visited Ireland, Singapore, Sri Lanka, and USA to attend and deliver lectures in several international conferences. We welcome you, sir, and we would request you to kindly commence the session.
Friends, all of us are aware that the seed of right to information was founded on right to know. And in Bennett Coleman and Company Limited versus Union of India, 1973 Supreme Court, this right to know was impliedly pronounced by the Supreme Court. In that particular case, the question that fell for consideration was some restriction, not only on the newsprint, but after the newsprint was given, price of the newspapers, area available for advertisement, some restrictions were put. For example, newspaper, which is known by common, which belongs to common ownership unit, number of pages limited to 10 pages, not more than that. There cannot be interchange between different editions of the same newspaper or newspaper printed. For example, Times of India, you cannot, Bombay and New Delhi cannot increase its circulation. Same circulation must be done. Then again, if Filmfare newsprint, it cannot be used for ultimately Femina. Prices of dailies were also fixed. And ultimately, area available for advertisement was also specified. Now, these restrictions were challenged on the ground that it affects the right of the newspapers, both with regard to quantity, with regard to quality. Quality depends upon the circulation. When the pages are limited and the area for advertisement ultimately is reduced, right to circulation of the newspaper is affected. And if there is a right to circulation of the newspaper, what happens is propagation of ideas, dissemination of the views and news are affected. Then if you put restriction on the area of advertisement, they may have to increase the price. Therefore, it was challenged ultimately as ultra virus Article 19(1)(a), freedom of speech and expression, which ultimately permits propagation of ideas, circulation of the views and news, etc., etc. Now, right to read is a part of, according to Supreme Court in this particular case, and Supreme Court struck down that particular newsprint control order because they made a distinction between newspaper control and newsprint control. Newsprint control is permissible because newsprint is limited. But once the newsprint is given, a newspaper control would offend Article 19(1)(a). Therefore, if you look into the scope of Article 19(1)(a), in 19(1)(a), what happens is, in Bennett Coleman and Company, which is known as the freedom of speech case, they made a distinction between newspaper control and newsprint control. Newsprint control is permissible, but newspaper post restriction on newspaper, fixing the price, prohibiting the area for advertisement, they said it offends Article 19(1)(a) of the Constitution. Now, in the first Indian Express newspaper private limited case, AIR 1959 Supreme Court had the opportunity to refer to decisions of the United States Supreme Court. 3 propositions I will cull out from that decision. It was a successful, succinct summary of the decision of the Supreme Court of the United States. 3, what is the rationale behind freedom of speech and expression, which includes freedom of press? First proposition was freedom of speech and expression under the Indian Constitution includes freedom of press. In fact, that freedom, 19(1)(a), is the mother of all other fundamental freedoms embodied in 19(1)(b) to 19(1)(g). This is first proposition. The second proposition is freedom of press rests on the assumption that widest possible dissemination of the information from diverse and mutually antagonistic sources. It is essential to the welfare of the people. I must know what is the left view. I must know what is the right view. I must know, all of us must know what is the central view. Mutually antagonistic sources, news must come, views must come, so that we may form our own opinion, what is good for the country. So that is, you will find the second function, purpose of freedom of under 19(1)(a). Third one was that such freedom is the foundation of free government of the free people. Underline the word free government, free people. And last but not the least, purpose of such guarantee is to prevent public authorities from assuming mental guardianship of the public mind. So these were suggested by Supreme Court of the United States, and Supreme Court of India was inspired by these provisions. Now, in second or third, I think, Indian Express Newspapers Limited, the case is reported in AIR 1986. Justice E.S. Venkataramaiah, he pointed out there is fourfold facets of free expression. Four functions it will serve if right is guaranteed to you. One is self-fulfillment, your creative abilities. You can give your own view. You can paint your own picture. You can express your own opinion. That is why self-fulfillment. Second, discovery of truth. You are able to discover the truth. Third, strengthening of an individual in decision making. If you are given that particular freedom, you are able to participate effectively, efficiently, and efficaciously in the administration. And last, balance between stability and change. So this is, you will find the function I'm giving you. Now, we look into the constitutional perspective of the Right to Information Act. Now, before I deal with the constitutional perspective, we must look into the triple test laid down by the Supreme Court. What are the triple tests when we look into the constitutionality? Every law, every delegated legislation, every enactment and every administrative order, three conditions are required to be satisfied cumulatively. First, compliance with fundamental right. Because Article 13(2) of the Constitution of India mandates states shall not make any law which takes away or abridges the fundamental right. So fundamental right is the test. You shall not violate it unless it is expressly permitted. So this is first test, compliance with the fundamental right. The second test is consistency with legislative competence. Parliament has got certain powers. State legislature have got certain powers. Certain powers are in the concurrent list in 7th schedule to the Constitution. Therefore, you shall not encroach upon it unless it is permitted by constitutional provision. The third one is conformity with any other mandatory provisions of the Constitution other than 1 and 2. So there are provisions outside legislative competence, part 3 of the Constitution, fundamental right. Those provisions also must be complied with. So this is, you will find the judicial review. So of late, what has happened is, due to the thrust of the human rights jurisprudence, transparency has become the rule. Because one is transparent, you become accountable. Secrecy is the exception. So then the question arises, if right to know is a part of Article 19(1)(a), as has been made out to be, then the question arises, are there any enactments, are there any rules and regulations which prima facie affect this right to, you will find, information? There are 4. One is the Official Secrets Act of 1923. Second, Section 123 of the Indian Evidence Act of 1872. Third one are civil service conduct rules made by the President or the Governor under Article 309. And the fourth is a post-constitutional law, Atomic Energy Act of 1961. These are the 4 enactments, etc., etc. And question comes for consideration when we deal with Right to Information Act, whether these restrictions are permitted, if I'm not mistaken, under Section 8 of the Right to Information Act. Now, there is another case, what is known as Yogakshema case, LIC versus Manu Shah, AAR 1993 Supreme Court, wherein there was a in-house magazine of LIC titled Yogakshema. Now, they used to give express opinion and introduce LIC policies, etc., etc. Manu Shah was the chief of a consumer organization, and he criticized that LIC policy. Now, this was controverted by the LIC in its in-house magazine. He wanted to give a rejoinder to that particular reply, saying that I do not agree. A contrary view, a contradictory view, you will find he wanted to give. Yogakshema editor, which is the official organ of LIC, but in-house magazine, they said permission is refused. So, refusal of permission, he approached the court. His contention was LIC is a state within the meaning of Article 12 of the Constitution. And therefore, whenever a view is expressed with regard to the schemes adopted by the LIC, practices adopted by the LIC, I must be in a position, if I am ultimately on the basis of the facts, on the basis of evidence, I must be able to controvert. I must be able to take an alternative view. And this alternative view should be published in this particular in-house magazine. The argument on behalf of LIC was that it is an in-house magazine. It is not an official media, etc. Secondly, editorial discretion of the editor is affected if permission is given. Rejecting the contention of the LIC, Supreme Court on appeal from the decision given by the Gujarat High Court, Supreme Court came to the conclusion, here is an organization belonging to the state. Resources of the state are utilized for publication. And you are giving certain practices, certain schemes. Every citizen has got a right, a contrary view, a contradictory view, and an alternative view must be published. Right to reply is a part of right to know, was what the Supreme Court said in this particular case. Now, there is another section I mentioned to you, section 123 of the Indian Evidence Act of 1872, section 123. It permits privileged, certain documents can be considered as a privileged document, and these privileged documents require particular method and the manner in which it is required to be communicated or permitted. Disclosure is to be permitted. Now, if you look into section 123 of Indian Evidence Act, 4 conditions are required to be satisfied. First is documents must form part of the official records. Secondly, such records must be unpublished. Third, such records which are unpublished must relate to the affairs of the state. And lastly, officer who is at the head of the as the head of the department must have withheld permission. If these 4 ingredients are satisfied, it becomes a privileged document. Now, in state of UP versus Rajnarayan, AIR 1975 Supreme Court, what happened was Rajnarayan wanted to get a document from the UP government pertaining to the visit of then Prime Minister Indira Gandhi during the election. It was an unpublished document. It affects the affairs of the state. Therefore, the head of the department said, I would not give permission. So the contention was whether it could be permitted. Supreme Court held in this particular case whether a disclosure of a document would harm the public interest would be decided only by the court, not either by the state or aggrieved individual. So therefore, we cannot give absolute, unguided, uncanalized discretion ultimately to the head of the department. So privilege to withhold the document was greatly revolutionized by another case, what is known as first judge's case, S.P. Gupta versus Union of India, AIR 1982 Supreme Court. The question that fell for consideration before the Supreme Court was, at that time, collegium was not there. Before collegium, the appointment of the judges of the High Court, appointment of the transfer of the judges of the High Court from one High Court to another, it was done by the Chief Justice, Law Minister, Union, Chief Justice of the High Court, and the Chief Justice of India. In the first judge's case, S.P. Gupta's case, the question was whether the consultation between these constitutional functionaries was substantive, whether it is effective. In order to find out whether it is effective or substantive, you must go through the correspondence between these three constitutional functionaries. Now, the central government said it is a privileged document under Section 123 of the Indian Evidence Act. Number two, what advice was given under Article 74, subclause 2 of the Indian Constitution? The advice which was tendered by the Prime Minister, you will find, to the President, it cannot be judicially reviewed. Therefore, Article 74(2) and Section 123 of Indian Evidence were raised. But Supreme Court said no. Because Article 74(2) is what advice was given. But if there is a document, if there is a material which contained that material will not be subject to Article 74 subclause 2. And Supreme Court also said 123, already it has been explained by Raj Narayan case. And Justice Bhagavati said, keep these documents before the Supreme Court. Because he said, again I will repeat it, open government with full access to information. If there is no open government, if there is no full access to information, we cannot come to the conclusion, we cannot ascertain whether there is a real, effective, efficacious, you will find ultimately effective and consultation between the Chief Justice of India and Chief Justice of High Court, Delhi High Court, or the Law Minister. Now, this is one aspect with regard to. Then second aspect is when we come to right to vote vis-a-vis right to know, antecedents of the election. Now, there is a juridical controversy whether right to vote is a statutory right, whether it is a constitutional right, whether it is a fundamental right. We will keep aside that controversy. But right to vote has been mentioned specifically under Article, if I'm not mistaken, 326, that adult franchise, a citizen of India who has attained the age of 18. Insofar as he has not been or she has not been disqualified either by the Constitution or the law. And on grounds ultimately of non-resident, unsoundness of mind, crime and corrupt, etc., etc. If they are not disqualified, they are entitled to vote. The question is, what is correlation between 19(1)(a) and Article 326? 326 of the Constitution. That came into, that was discussed, you will find, in two cases, both human rights organization. For example, I think it was Association for Democratic Reform, PUCR, these two organizations. Because there was a recommendation made in the 178th report of the Law Commission that we must know the antecedents. We must know whether the candidate, what are his assets, what are his antecedents, what are his educational background, whether he is competent to contest for election, whether he will be useful. These antecedents are required. So they went to the court and said, Election Commission must do this particular thing, etc., etc. Now, Supreme Court said, yes, unless you have got the requisite, relevant, reasonable, rational information before you, voter cannot decide what is the capacity of the elected or about to be elected. Therefore, of course, there was a legislative response to that particular recommendation. You will find ultimately, hesitantly, it was done by the legislature, where they introduced Section 33A and 33B of the Representation of People Act of 19. Therefore, right to information every information with regard to the candidate, because we have whether he has been convicted, whether any criminal case is pending, or what are its assets not only of the candidate, but of his spouse and the person who are dependent upon them. Now, all these things you will find, etc. Then another question is, under Article 21 of the Constitution, Supreme Court has said there is a right to clean environment, which is a part of right to life. So question comes for environmental information are also required. So because there may be a project, there may be a policy, there may be a program which the government, center, state, or local government wants to initiate, then it may affect the environmental atmosphere of the society or the part of the society. So they must know. So that is why they said there is what is known as right to information is required. I think Rajasthan High Court in L.K. Kulwal versus State of Rajasthan said it is right to, you must give that information. Information is given. There is because nowadays the question is not merely of representative government. Because for the last 50, 60 years, we have been overemphasizing only representative government. But what we require today is, as has been pointed out by Dr. S.P. Sathe in his book on administrative law, we want a participatory government. We must be every individual or majority of the individual must be able to participate effectively. That is what Justice E.S. Venkataramaiah said. You will find in Indian Express Newspapers Limited 1986 case that is taking a decision, strengthening the decision by an individual. Then governance becomes participatory. So far, government has been only representative in character. As soon as the elections are over, we give up our role to participate. And when the next election comes, again, we decide whether the same candidate must continue. No, participatory, etc. Therefore, then there is a last point with regard to Article 21, because the relevant articles involved are 19(1)(a), Article 21, Article 14 also, because these three articles are a kind of a golden triangle. 21, 13, according to Maneka Gandhi's case. Then the question comes, because in A.K. Gopalan versus State of Madras, the first constitutional case ever decided by the new Supreme Court, AAR 1950, page, I think, 27, subject to correction. In that particular case, in A.K. Gopalan's case, they followed theory of exclusivity of fundamental right. If 21 and 22 are applicable, 19 is not applicable. Later on, if 31 is applicable, 21 is not applicable. So they made what is known as theory of exclusivity of fundamental right. But later on, the Supreme Court in bank nationalization case or Bennett Coleman case, they said no. It is a composite code. Maneka Gandhi's case read together. It is a composite code. Article 21 in Karak Singh versus State of Uttar Pradesh, Article 21 is the residue. After taking into account, if whatever is not mentioned in 19, it is enumerated, it is articulated in Article 21 of the Constitution. So it has become a charter of enumeration. That's why right to life, right to personal liberty, right to live with dignity, right to decent, all these fundamental freedoms which are not explained either in Part 3 or Part 4. Supreme Court has looked into Article 21 of the Constitution. So right to privacy is a part of right to information. Right to privacy. What is this conflict? Because sometimes there can be a conflict between right to privacy, because privacy of my own that relates to family, marriage, procreation, motherhood, childbearing. Can anybody publish it without taking the consent? Whether it is truthful or false, whether it is critical or laudatory, or if it is published without the consent of the aggrieved or affected individual, could they be liable for in action for damages? These questions will have to be, you will find, which was looked into by the Supreme Court in several cases. Rajagopalan versus State of Tamil Nadu. Right to know, right to privacy. Whether prior restraint to prevent publication, which may be defamatory, which may be in order, etc., whether it is permissible. In Otto Shankar, Rajagopal versus State of Tamil Nadu, the court said right to information is substantial, it is legitimate, it is overwhelming interest. Likewise, prospective spouse, whether he or she, whether can approach the hospital to get an information whether the prospective spouse would be suffering from AIDS, whether the former has a right to information on the latter's disease. Court said yes, otherwise it will affect the right. Sometimes, therefore, there can be conflict between these, and these conflicts will have to be, because the question is, if right to know has been made under Article 21, things would have been clear. But right to know, right to reply, right to dissemination, right to circulation, right to propagation of idea is under Article 19, 1A of the Constitution. Therefore, the source of right to information is under 19.1A. And 19.1A itself is not absolute. There are reasonable grounds under Article 19.2. Three things you have to remember about reasonable restriction. First, with reference to Article 19. First, restriction must be reasonable. Reasonable, according to Chintaman Rao versus State of Madhya Pradesh, AAR 1951. Reasonable means a choice of course which reason dictates. So there are relevant factors which have to be taken into account. What is the duration of restriction? What is the object with which restriction is imposed? So all the relevant consider for choice of course which reason dictates. This is first reasonable. And if you look into the Constituent Assembly and the debates and the later on, originally 19.2, the word reasonable was not there. But other clauses, reasonable was there. I think the first amendment to the Constitution inserted rightly the word reasonable. So reasonable means a choice of course which reason dictates. This is first. Secondly, when you put restriction, you cannot put restriction by an administrative order. You have to put restriction by law. Imposition by law. Law would mean ordinance. Law would mean enactment. Law would mean delegated legislation. Okay, but not by administrative order. That is the second requirement. The third requirement is check up, which is the fundamental right. With respect to fundamental right, for example, 19.1A must be read with 19 clause 2, only on those grounds, not other grounds. In the interest of general public, you cannot impose a restriction as far as freedom of speech and expression is concerned. But if it is a freedom under 19.1D, E, 19.1G, in the interest of general public, and this interest of general public under clause 19.5 and 19.6 have been particularized or asserted in a particular manner under 19.2. And there are grounds indicated, for example, in the interest of sovereignty and integrity of the country, in the interest of the security of the state, in the interest of public order. decency, morality, in relation to contempt of court, in relation to defamation, in relation to incitement to offense. Only on the specific ground you may be able to put restriction. That is why in all the freedom of speech cases, government would argue it is a business within the meaning of 19G. Since it is a business, we are regulating only the business interest, then the restriction would be wider restriction in the interest of general public. So now, after having dealt with this particular case, now the question that is to be answered is, why, what is the purpose of Right to Information Act? Why Right to Information Act? What is the rationale? The following things come to my mind, because the source of right to information is 19(1)(a), as it is made out to be. Therefore, grounds for imposition of restrictions should generally be 19 grounds mentioned under 19(2). But I don't know, under section 8 does not reproduce the grounds under article 19(2). Because in that I don't remember section 66 of the Information Technology Act. Shreya's case, you will find. The law was struck down because the expert was an expert in criminal law. He was not an expert in the constitutional law, to the best of my knowledge. Because the words used is annoyance, which leads to this one, etc. Therefore, only the grounds on right to Information Act, provided it is grounded under 19(1)(a), must be the ground stated directly or indirectly. You will find mentioned under Article 19(2) of the Corporation. Now, we have adopted a parliamentary form of government. Rightly, wrongly, there has been a clamor for amending the Constitution, but the Supreme Court has said parliamentary form of government is a basic structure of the Constitution. So therefore, why I am telling you all these things is, in a parliamentary form of government, the distinction between the legislature and the executive is very thin and obliterated. Not real strict separation of powers like the American Constitution. Article 1, Section 1, Article 2, Section 1, Article 3, Section 1. So therefore, there is a possibility when the government is only representative, there is a possibility that corruption, nepotism, and favoritism could be there on the part of the executive. Because what executive decides, legislature makes the law. That is ultimately you will find. Therefore, this abuse and the misuse of power must be restrained. Favoritism, nepotism, and corruption should be to the minimum. The discretion conferred on the individual ultimately must be. Now, in order to do that, you require right to information. Your attention is kindly read yesterday's Times of India. Supreme Court policy announcement must be notified within reasonable time. A decision given by Justice Chandrachud and Madam Justice, I think, Indu Malhotra. So both of them have decided, because there was a policy regarding electricity tariff, that if you do this, electricity, if you start this industry within the specified area, electricity tariff will be less. This policy was announced in 2012. But later on, you will find 2015 or so, they prospectively said that this will be done. Now, yesterday, day before yesterday, it was decided. You will find by the Supreme Court, published in yesterday's newspaper, Supreme Court said, no, you must, whenever you have got a policy, whenever you have got a program, you must publish it. You must communicate it to the effect, because the trust of the people. People trust you. You are the trustees. Government is the trustee. And therefore, failure to do so ultimately is arbitrary, unreasonable. Article 14, doctrine of legitimate expectation, was invoked in this particular case. Today's newspaper, you just look into it. Don't first, right to privacy. Delhi High Court seeks center's response to PIL against government surveillance system. So surveillance is there by the government in each and every, through you will find intelligence, etc. The question, the contention raised by our advocate, you will find, was that it is against right to privacy. Take another same thing, today's newspaper. SC orders CCTV surveillance of police and probe agencies. So different interpretations are possible, because custodial death must be reduced. There is a surveillance. But if the surveillance is done in order to find out what that man does, where he talks, where he goes, etc., that is another area that right to privacy may be done. And yes, last point I wanted to make it, we have got a fundamental right to approach the Supreme Court under Article 32, and the constitutional right to approach the High Court under Article 226. If there is a right to information, then judicial review is facilitated. It is enhanced. Suppose I want to know who are all promoted. What is their seniority? If I've got enough time, if I get that information, I can say, if it is a public institution, seniority has been bypassed. So it facilitates judicial review. Same thing is true about ordinary suit, civil procedure code. You can get an information which is unpublished. Of course, there are mandatory information which are required to be given under the Right to Information Act, saying that what is required, etc., what is the structure of the administration, what is the budget, what are the steps. Apart from that, with regard to the promotion, with regard to the conditions of service, with regard to the disciplinary matters relating to the employees or students, etc., if you get an information, what happens is it facilitates judicial review. So for Right to Information Act, you find the state is made transparent, state is made accountable, and affected. All of us who are serious and sincere citizens of this country can participate in the admin, provided that information ultimately is available. Now, the last point I wanted to make it very clear. Under the Constitution, there is a presumption of constitutionality. Under the administrative law, there is a presumption that the administrative official will exercise his function honestly, in good faith, objectively, not whimsically or arbitrarily. So, for example, a law is passed by the parliament. A law is passed by the state legislature. Now, entire information relating to passing of that particular law, why the law was passed, notwithstanding the fact that is being debated, discussed elaborately within the legislature, there may be some other reason behind that particular law. So, presumption of the constitutionality means law is presumed to be constitutional. If there is a Right to Information Act, if I can get some material, some records, some information, some inputs, then I will be able to challenge it effectively. Same way, under the administrative law, even though there is a presumption that the action was done by the administrative authority in good faith, if I can get the information, why, where, how that particular delegated legislation or discretion was exercised, if it is possible, I am able to facilitate not only judicial review, even the legality of that particular action can be challenged, provided we are in a position you will find ultimately to get the relevant information. Thank you.
Thank you very much, sir. I think we all have looked at the constitutional dimension in terms of the history, background, and the kind of push the Constitution has given to this right to information. The contribution of the Indian judiciary is noteworthy. I think they have laid down the path for a new generation of rights to be, experienced, and through the Right to Information Act of 2005, I think there is a process in which this right can be exercised. Earlier, probably, the only way this right could be exercised was going to the judiciary. But right now, I think there is a process that is involved, and that really makes this right justiciable to a larger extent. Thank you very much, sir. Thank you for sharing your expertise, your experiences, and giving us your time in taking us through this dimension. We are indeed grateful to you. Let me now just turn to our team and ask them if there are any questions that Professor Mallar has been asked by the participants and the students.
Hello, sir. So there is one question that has been raised by Mr. Vikas Yadav. So it goes as, does RTI override the Official Secrets Act?
Yes.
There is a provision under the RTI Act. It is overriding. But if the grounds stated in that Official Secrets Act are same grounds which are mentioned under Section 8, then sometimes you may not get the information. If there is a conflict, the court will decide.
Yes, sir. So the second question,
if I'll add to Professor Mallar's answer. The answer to this is in the context of the fact that RTA Act has not fully overridden the Official Secrets Act, right? The overriding effect is only for any kind of inconsistency that may arise in reading these two legislations. Now, the inconsistency comes from Section 5 of the Official Secrets Act, which talks about classification of records. And to that extent only, there could be an overriding effect. Otherwise, the RTA Act complements the Official Secrets Act, and the Official Secrets Act is an independent legislation having its own effect. So, the overriding provision is a general provision. Only to the extent of that inconsistency, any overriding effect would be read from the RTA Act.
yes, sir.
Can government employees apply for RTA to government? Dr. Devan, I think yes, you can definitely apply, but you do not apply as a government employee, you apply as a citizen. So please segregate your role over there. I don't think as an employee you have any right to information. As a citizen, definitely you have a right to information. So you cannot, in your official capacity, using your official letterheads and your official communication channel, apply under RTA. So I would say, as an individual, in your personal interest, in your personal stake, you can go ahead and apply RTA to any government agency.
So we have some of the queries from the students. So the first question that I have is, can a petitioner or a respondent file an RTI application to the concerned court asking for documents of a pending or disposed case which he or she has submitted to the court? The court cases during the hearing? If yes, who is the PIO, appellate authority, responsible for this?
So the High Court and the Supreme Court are competent authorities under the Right to Information Act. And competent authorities under the Right to Information Act can actually make their own rules for the right to information. So this has already been discussed in the course. Kindly refer to that. It's a very important provision. So RTI Act has two sets of rules. One that is made by the state government or the central government, as the case may be, one that can be made by competent authorities. Now, the Registrar General of the courts are generally the officers who could be considered as the information officers. And you will notice that as per the orders of the Supreme Court, petitioners can seek information, but they have to follow the High Court and the Supreme Court rules for seeking the said information. So the courts have said that they do not want petitioners or citizens to use the RTA Act to circumvent the rules of the High Court and the Supreme Court. So if you are a petitioner, you have a cause, you have a locus to seek information about your litigation or any other matter that is connected to your litigation from the court. But as a litigant, which Raghav did mention, that if you're a petitioner, then you're a litigant. And hence, as a litigant, you will be bound by the court rules to seek that information and not RTA. So please distinguish your scope over there. You're no longer an ordinary citizen who will use RTA Act. You will be a litigant, and a litigant can only seek information from the court under the High Court rules or under the Supreme Court rules.
Thank you, sir. There is one more question about the political parties. So the query is that are political parties bound by the Right to Information Act? And if so, did they appoint any public authority?
We have also addressed this issue in our course. We have taken this judgment, and we have said that the political parties were brought within the purview of the Right to Information Act, but the compliance that is required from the political parties is not yet in place. For the simple reason is that the judgment is it is debatable, because the test to bring political parties under the Right to Information Act was based on the indirect funding test. And the indirect funding test is a fluid test. It is based on judicial interpretation, and it is subject to judicial review as well. Currently, as you see, the political parties are not a government agency. Kindly note, political parties are not state under Article 12 of the Constitution. The political parties are not created by the Parliament. The political parties are not departments and ministries. And hence, political parties are autonomous agencies that are probably voluntary organizations, which may probably have received some kind of benefit from the government in terms of land or in terms of tax exemptions that are applicable to the political parties. So this is an indirect funding test which the CIC has imposed. Currently, there are challenges about political parties that are there in the central level. There are a lot of political parties which are just state. So they do not have a national presence, and they are not national political parties as recognized by the Election Commission of India. So we have to answer and say that not all political parties were included in that CIC judgment, and hence they do not come within the purview of the RTA Act. It was a case of only the national political parties that were involved, and the CIC did hold that the political parties come within the purview of the Right to Information Act. But this is subject to a final review and decision of the courts.
So there's one more interesting query that we have from Mr. Vinod Ugare, sir. The query is, can I ask information relating to the RTA applications previously filed in the whole year, with full information of details asked in that application?
Yes, you can, but it is definitely going to be voluminous. So if you are willing to pay, and if the PIO is willing to give, I think it can be given. See, the whole process of RTA application itself should fulfill the transparency rule, right? If nothing else is given, at least RTA application related information should be given. There is no problem regarding the same. But I believe that most of this is filed as a statement every year about the number of applications that are received by each department, how many have been disposed of, how many are pending, and how many have been rejected. This is a kind of a statistical data every public authority must publish at the end of the year, right? I believe that in case the citizen is keen to know this information, it is better that he does not seek the information. it is better he seeks for an inspection of those records.
So there's one general query that has been raised, sir. This is pertaining to the good governance in the society. So the exact query is, please elaborate on good governance in the society, sir.
I think Professor Mallar can start.
Yes.
I will only add to what he says.
No. See, the good governance would mean it must be transparent. Government should be transparent. Government must be accountable. And there is a difficulty when we are talking about transparency and accountability. For example, under the Constitution, executive is accountable to the legislature. That is the fundamental principle. Whatever action has been taken by the executive, legislature must question it. But are we questioning it in the right manner? Now, assuming it is, etc., then comes for legislature. What is the accountability of the legislature? Only through election. But when it comes to the judiciary, there is no specified accountability. Commitment to the cause of the Constitution, discharging the functions in accordance with the tenets of the Constitution. That is the accountability. And sometimes what happens with the Supreme Court is it becomes supreme because it is final. So all these things are there about accountability. And therefore, from the representative government, it must go to self-rule. You look into the 73rd, 74th constitutional amendment, panchayat, etc. Idea is we must be able to rule ourselves. When the country is vast, with lot of population, diverse lifestyle, religion, etc., it's not possible that representation will work. In the sense, it worked in Greece at that particular time. So therefore, self-rule is required, for which decentralization is required. And everybody must be imbued with rule of law. But today, if the rule of law is against me, I challenge it. If the rule of law is against others, then we threaten them. Everybody must follow the rule of law to the best of ability, her ability, or his ability. Then only question it. That is why question came about fundamental rights. So one authority said, fundamental rights lie in the hearts of women and men of this country. If it does not lie, no law, no amendment, no constitution, no court can save us. So therefore, we must try to imbue that particular rule of law. We must be transparent before I ask others to be transparent. That's the transparency. Merit is the criterion. To the similarly situated people, same law will be applicable. Same law must be enforced for similarly situated. So these are all the fundamental concepts and basics of rule of law. And rule of law must be like you will find what is known as Sudarshana Chakra. Once you send that Sudarshana Chakra, all the heads you will find must be rolled, irrespective of the prohibited markers, which are given in the fundamental rights. We are not prepared for that. We are only interested in the power. We are not interested in the power addressing. That is, you will find, without getting into politics, etc., etc. So good governance means both from the point of view of part 3, civil, political liberties, we must be able to go to the court. But socio-economic framework is to be implemented. Part 4 of the Constitution, we are not in a position to implement it because Dr. Ambedkar, the architect of the Constitution, said behind fundamental right, judiciary is the teeth. Behind part 4, judiciary is not the teeth. It is the electorate. But there are no options available among the political parties. One incompetent political party is replaced by another equally incompetent political parties. Part 4 of the Constitution is the constitutional manifesto, which gives, according to me, it is an infrastructure. The superstructure is the fundamental right. Now we have got superstructure as infrastructure. So there is a kind of an enigma in the Indian polity. So that is transparency. Everybody knows what is transparent. There is no questionable. Power must be used for the purposes intended by the provisions of the Constitution, provisions of the law. That is the purpose. And in fact, indirectly, what Mahatma Gandhi said, the trusteeship concept. Power is ultimately, in fact, Justice Chandrachud, you will find in yesterday's judgment, he is telling that trust is reposed by the people in the state. Now, if you try to do something against it, then your action is arbitrary, capricious, and whimsical. And therefore, Article 14 of the Constitution is attractive. Thank you.
Excellent. I can just supplement to what Professor Mallar has already said. There are different agencies that have come up with tests for determining good governance. And if you look at the governance index that have been developed, good governance is probably tested on certain parameters. For example, if you look at what World Bank says, they have 4 major parameters to test good governance. First is whether citizens have a right to participate in decision-making processes, which talks about basically political freedom and political stability. Okay, that is one of the tests of good governance. The second test of good governance is what is the government orientation towards? For example, is the judiciary efficient? Is the bureaucracy efficient? And is there any method to tackle corruption? That is also one of the second important tests in which the World Bank says we can know whether good governance does exist in a country or not. The third test that World Bank does suggest is on the social development. It is about income distribution. It is about human development. Probably in terms of what kind of rights have been given to human beings to fully explore their intellectual capacities. The last test that World Bank does prescribe in terms of governance index is the economic management. So it talks about GDP. It talks about how independent is the central bank. It talks about how the country is progressing in the world view. So I think good governance has all these components to test whether the country is marching towards the same or not. Having said this, please note, when we say RTI and good governance, we believe that RTI is one of the tools that has tried to ensure good governance. How has RTI become a tool of good governance? Because please note, if you say that it is about citizens' participation, which is the first test that I told you that World Bank insists about, it means that citizens can participate in the decision-making process of governance. And how can citizens do that? Citizens can do that if they're well informed, if they have right to information about what the government does and what it does not do. So holding government accountable and having a mechanism to hold the government accountable, trying to ensure that the government is not a government of secrecy but a government of openness, is what the RTA facilitates. And hence we say that right to information is a tool to enable good governance in the country. And hence this act has probably catalyzed the method of good governance and has brought about a new era of ensuring good governance vis-a-vis India.
Yes, sir. There's one query from Mr. Sharad. He has made an interesting observation, sir. He says, I wish to draw your attention towards a new trend where the Central Information Commission has passed adverse remarks on large number of RTI applications filed by one person. Is this a dangerous trend? And where is the boundary to demarcate, and who will decide whether the RTI applications are genuine and coming from public spirited person, or the RTI applications are not genuine, especially when the Right to Information Act itself states that no reason is required for filing applications? Is the genuineness of RTI application presumed, or now RTI applicant will have to show why they have filed the RTI applications? Shall RTI application also seek quota on how many applications under the RTI can be filed by an individual? This is a pretty query.
I think it's a wonderful question, but the question has a very simple answer. The answer is right to information is a right, and no right is absolute. No right can be, overused. Right? You should use it wisely, but not misuse it. Please note, do I have the right to go to the court and file a public interest litigation? Yes, but I cannot misuse it. There are guidelines. The court will ask every time when you come, why are you coming? Right? So there are guidelines on how a public interest litigation can be filed. Every right that is mentioned in the Constitution, be it the freedoms or be it the rights, every right has to be exercised in a reasonable manner. I think abuse and misuse of any right in a legal system is expected. And hence, somewhere the bodies in the RTI Act, be it the CIC, SIC, or even the courts, will definitely try and check abuse and misuse. So, to answer saying that every year every citizen can file only 10 applications, no, it is not the case. But I think there ought to be some kind of level in which this can be handled. So you will notice that citizens do seek information. Now, you don't have to give reasons, definitely. But there has to be some kind of a purpose or objective behind seeking the said information. And you would expect government machinery to also have, adequate infrastructure and physical ability to respond to those RTI applications. But the final answer to this question is, I think we are still dealing RTI in a physical manner. And that is where probably the Information Commission is kind of concerned. Once we move from physical to digital, I'm sure the CIC will say, don't worry, how much ever information you want to ask, you can ask, and the public authorities will be able to give it because it's all digital. It's not difficult to give digital information. So then there may not be these observations as we move forward in digitalization of government records and information is what I perceive will be the final solution. But nevertheless, I think those citizens who probably too frequently ask information to the same organization will probably face some checks and balances from the Information Commission as regards the exercise of their rights. And hence, citizens must exercise caution, and please also believe that when you have a right, you also owe a duty. No right is going to be meaningful unless we have exercised our duty towards the right to information, towards this area of law. So your duty is first. The right should be exercised later. So don't abuse it, don't misuse it. That is, I think, the first caution. And I'm sure there is nothing wrong if some checks and balances are established towards the exercise of this right.
I have got one question to Professor Sairam Bhat, just to elucidate. After listening to you, I will elucidate. Is there a up to which year I can go for information?
Sir, definitely, sir. Sir, this is based on the Record Management Act of 1993 and 2010, where there are limitations to how old information can be asked.
What is that? 25 years? Or what is it?
No, sir. It depends upon the record itself. Oh. So the government department.
Why I am telling you why I asked this particularly? I knew one applicant from Bombay continuously was asking information of all the institutions, including Bombay University. After asking the information, he will sell this as Raddi. It has happened. It has happened. Because about Bombay University, what was the enactment, which year, this one, give us the authorities, this one, and then he will get it. And he is an illiterate. He will get that particular application, pay for 10 rupees or whatever it is. He will directly go and sell it as Raddi. That is the abuse.
Yeah, I agree. Raghav, the participant's name, the one who has asked this question?
This is from Mr. Sharad, sir.
Sharad, I should also tell you that there are a few respected RTI activists. I can definitely give you names of them, like Sri Subhash Chandra Agarwal. Now, courts and CIC has never told Subhash Chandra Agarwal that you can file only these many applications. Never. And Subhash Chandra Agarwal has filed numerous applications. No limit has been set. Why? Because he has established himself to be a very serious RTA activist, trying to bring in some kind of accountability at different levels of the government. So nowhere I have seen SC Agarwal being told saying that you can only apply 10. No, not necessarily. So I think it depends upon the responsibility of the citizen to prove his bona fideness in his pursuit of the RTI, regime. So I think it is all upon us to show our bona fide, and if we show our bona fideness, I'm sure no information commission is going to stop your journey in holding the government accountable under the Right to Information Act.
So I'll just add one more point to this, sir. It is not just about the citizens' right to seek for information, but it is also from the perspective of the government to provide that information. Because if it is draining excessive resources of the government, then there'll be restraint to give any kind of information. And it is also the time that they have to spend on providing such information for any kind of questions which is not relevant. So keeping that perspective also in mind, the CIC has probably come out with such a
the Supreme Court, Raghav, in the Aditya Bandyopadhyay case, has very clearly said that the government machinery cannot be misused and diverted for excessive RTI queries. So the Supreme Court has clearly laid down the test about what is permissible, what is probably discouraged. I will never use the word impermissible because you still have the right, but I think exercise it wisely and do not misuse
it. So there are two more queries from the YouTube that we have received, sir.
First, I will take it up. Larger public interest, Sachin Kumar. Yes, I think Sachin Kumar, it's a very good question that you asked. What is larger public interest? I think you will see this word of larger public interest being used in Section 8, which very clearly says two things, Sachin. And even if the other participants are hearing to me, please note it down. That you all say that under Section 6.2 of the RTI Act, no reasons have to be given. You're absolutely right. But if you're seeking exempted information, kindly note, and if you think that it is exempted but still should be given to you in larger public interest, you will have to give reasons. You have to substantiate what that larger public interest is. And if you are able to do that, and if the Information Commission is adequately satisfied that an exempted information can be provided because there is larger public interest, that exempted information can definitely be given to you. Right? Now, what is a larger public interest? Friends, there is no given test of what is a larger public interest. It would depend upon a case-to-case basis. A larger public interest could be about even one individual whose rights may be adversely affected if that information does not give. So the larger public interest is not some 10 or majority of people. No, even one individual. For example, Vikas was proposing to show this slide to you, in which very recently a wife was seeking some information of her husband. And this information the wife probably was given, though it was exempted, because it would have affected her right. So if the denial of an information is going to adversely affect my interest, my right, or it may adversely affect any kind of benefit that I'm about to receive in the coming days, that would also fall within the definition of a larger public interest. So larger public interest clearly means that you do not get the right of, say, right to privacy. Privacy or personal information is exempted. But in some cases, please note that right to privacy will be subservient to the right to information of that individual. So this is where there are two competing rights. One for protection, the other against disclosure. The disclosure right will prevail over the right to be withheld, or right not to be giving this information. So that is what privacy actually means in that sense, right? So personal information can be shared, and the only ground on which it can be shared is that you have to show that there is more benefit if this information is provided to the citizen. That is what the test is all about. So no confirmed test. It is nothing that is stated in the law. I think through judicial pronouncement, there is an evolution of what that larger public interest test is there. And that is where the case laws do help us and guide us in determining the same. The next question is same RTI filed at different banks. Now, there is nothing wrong about same RTI being filed at different banks. The only thing is what information you're asking, right? Now, the gentleman has said that when first appeal was filed, annexing all other bank replies, it was still rejected. Now, I don't know what are the grounds of rejection. So we'll have to study this matter. It's not easy to address this query. But what information you ask from these banks is very pertinent to note. You can ask the same information from all the banks. There is no problem. But please note, when you say all the banks, let me clarify and tell you, all banks don't come within the purview of RTI Act. Only public sector banks come within the purview of RTI Act. ICICI Bank, Axis Bank, Yes Bank, HDFC Bank are not public authorities under the RTI Act, and they do not come within the purview of giving you this information at all. Now, this is first point. Second point is, most of the information that banks are holding are in fiduciary capacity. So they will never give you this information because they have the right to withhold this information in a fiduciary capacity, and they are confidential information. They are information about commercial dealings, customer information, and hence they do not have any duty to disclose all this information to the citizen. So you will have to know, the ambit and scope of the role of the bank under the RTI regime.
Yes, sir. These were the queries that were raised from the students as well as from the YouTube channel.
Because it's a very short presentation, I think
Yes,
we allow Vikas to do that, and after which we can close in another 5 minutes. Vikas, quick and short and crisp.
Thank you, sir. Thank you, sir. I will start. Sorry, this is. So, most of the facts were discussed, so I will not take much time. So, as we know, about 120 countries of the world have made the right to information laws, and the sustainable development goals also makes that each and every person has the right to information. Now, 28th September of each year is celebrated as National Day for Universal Access to Information. In 2020, the International Day for Universal Access of Information was devoted how the right to information can be used in the case of COVID-19. If you go to this link, you will find the discussions and celebrations that were made by the UNESCO at that day. Second, I will not.
Just to add to what Vikas is saying, I think that document is very, very pertinent because it does balance out the interest of accessing information during this pandemic and the necessity to protect privacy of those who are involved in the pandemic. They may be the frontline workers, they may be those who have volunteered in the vaccination process, those who have unfortunately succumbed to this pandemic, those who have been found positive during this pandemic. I think please know all these are very, very pertinent information. But the document that was released does say that there ought to be a balance between the right to information, the reason for ensuring its transparency, whereas it is also important to protect the privacy of individuals in the whole process. So balancing of rights is very, very relevant and very important because.
I will not deal with this case because this case has been dealt by us. So I
Yes.
will just.
This is the case which I just referred to about husband's income. And generally, the husband's income can come within personal information and maybe not allowed. But the wife was allowed to get this information because the CIC said there is a larger public interest in the wife knowing the same.
Sorry, in 2020, one of the applications that we have used is the Guest to app. Now, one petitioner made the Halden application seeking information. Who has made the app and what are the details? The ministry has said they don't know who has made the app, means the application, and the and the person was sent from one ministry to next. So after 2 months of saying from one ministry to another, the person was not made a information about the person who has made the application. When the complaint came to the CIC stated that this was not expected from the ministry, and there was showcased the ministry why fine should not be imposed on them. Uh, Section 20 of the act. So that is the case. Sir, I will move to the next case, sir. Ample. So one of the main question that comes is when you donate funds to a temple, can you ask information from the temple about what funds of what they have done with those funds, or you can ask the information about how the funds have been utilized or not? The CIC has said, sorry, the Kerala High Court and CIC both have said कि merely when a institution seeks contribution from the public, that doesn't mean that a public becomes a public authority. Per section 2H. The court has said that there is a substantial difference between the concept of funds raised by
Public contribution.
and funds made by the state government. So this distinction was made by the courts. Sir.
Yes, please note that the funds provided by the government clearly are accountable under the RTA Act, whether directly or indirectly. But when public donations are received by a particular temple, there could be other mechanisms to ensure some kind of accountability, but you cannot probably bring it under the Right to Information Act. So please note the body that you seek information from has to fall within the purview of Section 2H, and it should be a public authority as such. From there on, you can definitely ask some information. But if the body itself is not a public authority, no such information can be asked, even if they are raising public donation and public funds.
To sum up the things, sir, I hope the participants have learned some information about these 12-week course, and if they want to learn more, the course was just an initiation point for the participant to know the about the ins and outs of the right information. But the start that they had, they can move with that into much other directions. We have some books and the website that they can look into. First book was by Professor Ram sir. I think you all know about this book, and if any participants want to purchase that book, they can ask the item to us. Second book that I'm going to deal with is by Anshu Jha. That book came in the year 2020, and very beautiful book, and it makes a distinction about how institutional change came in the governance structure, and how it has shifted from secrecy to openness. Next book I want matlab, the participant participants can look into is the book by R.K. and this is a PIO's guide to RTI. So if any participant is a PIO, they can surely look into this book. And the last book that I'll recommend will the high to information, what to share and what not to share. Uh, Apart from these books, there are some websites too that the participant can go and find for much more studies. That's it, sir. I will end the presentation.
What
Thank you, sir. Thank you, Mallar sir, for that insightful and enlightening session on the constitutional perspective to the right to information. And it was, I hope all the participants were really careful and keenly listening to the lecture that was delivered by Professor Mallar sir. And thank you, Sairam sir, for answering all the queries and adding on to the Mallar sir's presentation. And also thanks to Vikas for making the presentation and bringing out the recent cases under the right to information law. And with this, we'll conclude the session. And we have ended the course, and the 12-week course has come to an end. And I think this is the last session that we will be having for the course. And I hope all of you have enjoyed the course during the 12-week. And we will, if there's any doubt, you can definitely contact us. And we have already given you the websites. So for more updates on different aspects of law, you can follow the websites that you have already been addressed. And with this, we'll conclude the session. Thank you all for joining.
On behalf of our team at National Law School, we would also like to thank NPTEL Madras for giving us this opportunity, because we have seen that over the years, MOOCs have proved to be one of the best means of knowledge dissemination to the masses. And we would like to assure you that this is just the start. If I'm sure there are many more students out there who would be more interested in legal education and learning, and we'll be very happy to offer more such courses. And on behalf of our team, I would also like to thank three of our associates, especially Vikas, Rohit, and Leanne, for being in touch with NPTEL and ensuring that we administer this course seamlessly. So thank you, one and all, and we bring this session to a conclusion. Thank you.